Now, we've had quite a lot of mention of international law or legal concepts throughout the morning. And it is true to say that this is to be expected, almost as anyone would tell you, anyone who's skeptical about whether international law is even a discipline of academic life would say that it is definitely the lingua franca, if I can say so, of almost any essentially political argument dressed up with legal pretenses. But there are some very serious legal issues that are not mentioned. I don't know how many of you know, for instance, that one of the key arguments of Turkey to claim that Israel has no right to impose or maintain a blockade is the argument that since Israel doesn't recognize Gaza, Gaza is not an entity which can be subjected by Israel to a blockade, which is an interesting circular argument, but it is definitely one that is being made by others. I don't know how many pause and think that whatever arrangement is ultimately reached about the actual physical representation of Palestine in UN bodies can have some consequences on a lot of other countries, like, for instance, the status of Taiwan in the United Nations. So this is a very complex field. I hope we will not go back over some of the arguments that have already been discussed this morning, but I do hope that we will have a good crack in the next 45 minutes at what are the legal implications for what remains, and it should remain, an essentially political issue. First, to kick us off, is Ambassador Tory who was on the receiving end from both sides, as it were, as the Israeli ambassador to the United Nations and as an advisor to a number of Israeli prime ministers. I think you wanted to speak from there, right?
Let me begin with a basic observation. I'm very baffled by the Palestinian move at the United Nations, and I will tell you why. You know, in Israel today, there is this mistake being made repeatedly that maybe it's my cell phone.
Now that is...
Could I give this to somebody to take it away? Thank you. Let me start again. I said I'm baffled by the Palestinian move at the United Nations, and in fact, my confusion somewhat reflects my own commentary on the way this whole issue is being discussed in the Israeli political world and the Israeli media. You hear frequently the assertion made that Mahmoud Abbas is going to the UN in September to declare a state. That's what's said over and over again. And then I sit back and think for a moment. I go, well, how are states declared? I mean, let's take 3 recent cases: Kosovo, East Timor, and South Sudan. Did their representatives go to the UN to declare a state? No. They went to their capital, and they either did it in their parliament or their prime minister held a meeting of some kind, and they issued a proclamation of independence. Take the case of the State of Israel, part of the confusion here. How did Israel come into being? First, you had the vote on the 29th of November, 1947, in which the UN General Assembly made a recommendation that a Jewish state and an Arab state should be established. It was rejected by the Arab side. Nothing legally happened with that recommendation. And the real next move was when Ben-Gurion, our first prime minister, in May of 1948, declared the State of Israel. He didn't do that at the UN, he did that in Tel Aviv. Subsequently, in 1949, Israel sought admission to the UN as a member state, a year later. But here, it's all sort of jumbled together, and therefore, my confusion and the confusion of many. Now, one thing is clear, particularly if you read the interview with Mahmoud Abbas in Newsweek that was several months ago. Mahmoud Abbas is not going out on a veranda in Ramallah and issuing a declaration of independence. And I don't think he really wants to do that. So instead, others are doing the work basically for him. Now, there is a Palestinian argument being made that you hear that there is no need for a proclamation of independence. Why? Because in 1988 in Algiers, Yasser Arafat declared the state of Palestine. There was not even any PLO presence, official presence in the West Bank at the time. None of the fundamental prerequisites of statehood existed or even could be asserted. But what's really confusing about those who rely on that 1988 declaration of a virtual state is that the Palestinians themselves continue to say, we're going to declare a Palestinian state. When I was at the UN in 1999, there was a Palestinian argument being made, well, the implementation accords of Oslo were signed in 1994, and they were for a 5-year interim period. When the 5-year interim period ends in 1999, a vacuum will be created, and therefore we must declare statehood. Well, wait a minute. If you said 88 was a real statehood, then how can you threaten to declare statehood in 99? And when the current round of discussion, which began in 2008 when Kosovo achieved its independence, that whole current discussion since 2008 again is saying, we have to declare a state. We, the Palestinians, have to declare a state. Well, how come you have to declare a state if you already declared one in 1988? One of the legal authorities on this issue of new states and how states are formed is a British professor named James Crawford, who in his very large book on the creation of new states made the following observation. If a new unilateral declaration is thought to be necessary by some within the PLO, on what basis was that of 1988 insufficient? In other words, there must be something wrong with that 1988 declaration, yet today it's being pinned on and referred to as the reason why there doesn't have to be a new declaration of independence, and you can just run to the UN and get UN membership without even having a real state. One of the questions I keep asking myself is, what do the Palestinians gain from this move? If they don't have a declared state, but they have an effort made at the United Nations. Now, we know that the United States and the Obama administration has been very clear. It will veto a Palestinian effort to get membership in the United Nations, which has to begin in the Security Council. So, as a result, it seems that the main focus of attention will be the UN General Assembly. Now, in the world of the UN General Assembly, you have all kinds of participants. You have full member states. You have observers. Observers don't have to be states. The PLO for many years, although the language on the Palestinian delegate says Palestine from a 1988 resolution, it was an observer, which was a non-state observer. The Arab League is a non-state observer. The Islamic Conference is a non-state observer. So you could have that status. Now it seems is going to happen is that the PLO will seek to upgrade its observer status to that of a state observer, somewhat like the Vatican, which is the only other state observer that immediately comes to mind. Now, let me be very clear about how many of us in Israel view this move. If the Palestinian Authority, which is represented by the PLO, declares that its status has changed, it is no longer the Palestinian Authority of Oslo, but it is a state in the UN General Assembly, albeit only an observer state, like the Vatican. A change in status of the Palestinians in the UN is a material breach of the Oslo Agreements. We're not talking about some, disagreement we have with the Palestinians over the size of the second further redeployment, or all the other issues that you can find in Oslo where Palestinians haven't always implemented what they were supposed to do, and frankly, Israel hasn't always implemented what it's supposed to do. This is a core element of the agreement. And let me also share with you, since I'm making such a strong assertion, the basis on which I say this. In the Oslo II interim agreement, which is the big agreement that allowed us to implement Oslo on the West Bank. Article 31 says very clearly, neither side shall initiate or take any step that will change the status of the West Bank and the Gaza Strip pending the outcome of permanent status negotiations. Now, those who were involved in drafting this language have spoken to me. And the clear intent of the drafters were two scenarios. Israel can't start annexing chunks of West Bank territory for defensible borders or whatever reason, and the Palestinians can't declare a state. Those two options were neutralized, and both sides had to resolve their differences at the negotiating table. But now we're going to have a UN resolution which says, no, we're going to change the status of Palestinian Authority territory to that of a state in violation of this clause. Moreover, we again haven't seen the draft resolution that's being cooked for later this month. But according to all accounts, it will specifically refer to the line of June 4th, 1967 as the borders of a future Palestinian state. So whereas the resolution of the Israeli-Palestinian conflict was supposed to be through negotiations, and one of the issues of negotiations was borders, the Palestinians want to resolve the border issue by going to the UN and obtaining the 67 line. Not negotiate with us, just obtain it. And that is a very serious problem. Let me just also add, I'll stretch my time a little bit. The Oslo II interim agreement, from which that phrase is taken, that clause is taken, was signed in the White House in 1995 by Yasser Arafat, the PLO chairman, and by our Prime Minister Yitzhak Rabin. It was also signed by countries that were witnesses to the agreement, who came to the ceremony, Egypt and Jordan. But for a discussion in London today, it was also signed by the European Union. Now let's say the European Union, in the General Assembly, decides to vote, or any European Union country, or important European Union countries, decide to vote for a Palestinian effort to violate the Oslo Agreements, to which the European Union is signed. What does that mean for the future involvement of the European Union in the peace process? Why should the Israeli public support European involvement in the peace process in the future if European countries are helping violate an agreement which they signed themselves, albeit as witnesses? So there's a serious problem here affecting British interests and European interests that should not be overlooked. I'll just close with several observations of what I think the Palestinians hope to achieve by this move. I mentioned the 67 lines. What they would like to do is resolve the territorial issue without having to negotiate the security issue. Our view is the order has to be in the reverse. We've got to know what you're willing to give us on security, and then we can talk territory, which is why we can't take a document from Abu Mazen that has all these detailed positions on everything. Let's see what you can do on security, then we'll tell you what we can sacrifice on territory. That basically, the move at the UN undermines our strategy, gives them territory without security. It gives them territory without having to give Israel the recognition it's seeking. And that recognition is not recognizing the state of Israel as a theoretical state, is recognizing Israel as the nation state of the Jewish people. Remember, the world came to Prime Minister Netanyahu and said, recognize the rights of the Palestinians to a state. He did it. He did it in Bar-Ilan University. But shouldn't we also get the other side of this, recognizing the rights of our people to their own nation state? And that relates to the third thing which I think the Palestinians obtained by this move. They get the territory, but they don't have to declare the finality of the peace process, that this is it, the conflict is over. The conflict is still open. And as I said earlier in the questions and answers, if you read Mahmoud Abbas's article in the New York Times from May 16th, he wants to continue the conflict through international legal mechanisms. That is a growing danger for Israel, but it's one we have to prepare for. Thank you.
Thank you so much. It's fair to say that there is a huge amount of countries that have sought membership in the United Nations without settling, as a result, their final borders, or without even having the borders settled. The other points I hope that you mentioned will be brought up by Dr. Shah when he speaks at the end of the session. The next speaker is Professor Shaw from a very distinguished and personally very dear to me institution, the Lauterpacht Center for International Law at Cambridge. I'm old enough to have actually been educated on old Lauterpacht's books, and I'm glad to say that he has succeeded in replacing them by his own writings. Go ahead.
Thank you very much. I must commence by referring to a highly controversial statement made by Ambassador Gold. He referred to James Crawford as a British international lawyer. He is not. He is Australian, and very proudly so. So that's clear. All our problems should be solved that easily. I start from what I think are three commonly accepted points, each of which has international, political, and legal imprimatur. First, Israel is a recognized state in the international community with a right to territorial sovereignty and to what the Security Council has itself called secure and recognized boundaries. Secondly, the Palestinian people have a right to self-determination, which has been interpreted to mean ultimately statehood. And finally, the conflict can only be solved by negotiations and agreement between the parties. There is also a consensus that the solution would encompass two states, Israel and Palestine, within the historic territory of the Palestine Mandate as of 1947, and that changes to the armistice lines of 1949 to 67 in this territory are permissible with the consent of the parties. The Israel-Palestine situation is very unusual in international legal terms. While mandate situations existed in the past as political domination by certain European powers over non-European territories without reference to territorial sovereignty, and while there are other examples of mandated territories coming to independence in a partitioned form, the decades-long conflict with the resort to force and terrorism and the particularly sensitive religious dimension is rare indeed. Self-determination is a right of peoples, but its interpretation is cloaked in some ambiguity, and it does not exist in a vacuum. It is contextual and relative to the rights of others. Both the mandate and the UN essentially recognized the right to self-determination of two peoples in mandated Palestine, and that was unique. The current unilateral initiative by the Palestinian Authority raises all kinds of difficult legal issues. Some of these arise because of historical circumstances, others because of pre-existing and still valid complex of agreements binding Israel and the PLO and its agent, the PA, the Palestinian Authority. The current PA initiative is a unilateral action taken in a matter apparently inconsistent with the approach and mechanisms it had itself adopted and agreed to be bound by. The fact that the ultimate outcome of the independence of Palestine is accepted by all parties does not legitimize the unilateral action as such. On the contrary, it casts a rather sharp light upon the actions of the PA and does appear to threaten the mutually agreed and internationally affirmed peace methodology. This brings us to the bundle of agreements between Israel and the PLO, which for shorthand being called the Oslo Agreements. These revolutionized the Israel-Palestine conflict. The essential points were that Israel and the PLO accepted each other's existence and agreed to work towards an agreed solution in a particular way. These agreements defined the legal situation as between the parties until such time as a final agreed settlement had arrived, and contained binding obligations for both parties, as the International Court of Justice affirmed in the Wall case. They have not been denounced, so continue in force for both Israel and the PLO. It is to be noted that the PLO was and remains simply a creature of these agreements. It was established by them and derives its powers and responsibilities and the limitations thereupon from them. It has no existence in legal terms outside these agreements. The Oslo Process commenced with the 1993 declaration, which provided for a Palestinian authority with jurisdiction over the West Bank and Gaza, except for issues to be negotiated in the permanent status negotiations. Various transfers of authority commenced from the Israeli military government and its civil administration to the PA. Of particular importance is the 1995 interim agreement, under which an additional range of powers and responsibilities was transferred to the PA, and arrangements made for Israeli withdrawal from a number of cities and villages on the West Bank. This agreement was witnessed by the US, Russia, Egypt, Jordan, Norway, and the European Union. This emphasized its central importance and status. The interim agreement specifically provided that Israel shall continue to exercise powers and responsibilities not so transferred, while the PA would not have powers and responsibilities in the sphere of foreign relations and only certain limited powers to sign agreements in the economic sphere. The agreement also provided that the jurisdiction of the PA would cover the West Bank and Gaza Strip, except for issues that would be negotiated in the permanent status negotiations. Those issues were defined as Jerusalem, refugees, settlements, security arrangements, borders, relations and cooperation with other neighbours, and other issues of common interest. This is usually taken to mean things like water and electromagnetic resources. As Ambassador Gold said just before, Article 31(7) stipulated neither side shall initiate or take any step that will change the status of the West Bank and the Gaza Strip pending the outcome of the permanent status negotiations. Now, the validity and importance of the Oslo Accords have been reaffirmed not only by the parties time and again, but by the Middle East Quartet, which is the US, UN, EU, and Russia, and others. The Quartet has consistently stated and emphasized its determination to seek a comprehensive resolution of the Arab-Israeli conflict on the basis of a number of UN resolutions, the roadmap, and the agreements previously reached between the parties. The roadmap of 2003 laid down timelines, target dates, a whole methodology. And the International Court in the Wall case, an opinion not universally regarded as entirely pro-Israeli, regarded this, the roadmap, as a negotiating framework for the resolution of the Israeli-Palestinian conflict. And the roadmap has been specifically endorsed by the Security Council in a whole raft of resolutions. In other words, both substantive and procedural requirements were laid down. There are two particular issues here. The first particular issue is that the envisaged unilateral action appears clearly inconsistent with the Oslo Agreements and what may be called the Oslo Process. This will raise a series of legal problems. First, the status of the PA itself. Secondly, the fact that the violation by one party of an international agreement would in law entitle the other party to adopt countermeasures, what's called countermeasures, such as suspending other provisions of that or other agreements between the parties, may even lead to the avoiding of the whole complex, Oslo complex. Thirdly, the totality of legal, political, economic and security arrangements laboriously built up by the parties over the years would be at best shaken with unpredictable consequences. Fourthly, the international witnesses to the Oslo Agreements may very well have legitimate grounds for grievance against the PO. The second particular issue is to what extent the Oslo Agreements may in fact survive any claimed Palestinian statehood. The agreements differentiated between a range of issues and what were called permanent status issues, Jerusalem refugees, settlements, borders, etc., that I mentioned before. These were and are particularly sensitive issues. It is logical, legal, and correct, in my view, that those matters accepted by the parties of such special status should so remain after statehood. Or to put it another way, the obligation to discuss and resolve such questions only at the permanent status negotiation stage should bind the new state of Palestine, should it arise, as it currently binds the PLO and the PA. The consequence of this in law would seem to me to be that East Jerusalem and the settlements would continue their current status after any Palestinian independence. That is, they would simply remain under effective Israeli control under the law of belligerent occupation, pending a final agreement, except for any areas that Israel may unilaterally decide to vacate. Similarly, the question of refugees cannot and could not be unilaterally resolved by the Palestinian state, and so would remain on the agenda, no less, no more. A word about statehood and boundaries. These are two separate matters for the following reason. Statehood is a matter for the international community as a whole, since it deals with the issue of membership of that community as such. The question of boundaries, however, is preeminently a matter for the states directly concerned. An international view as to a particular frontier is of illustrative importance only, and may only really reinforce an acceptance by the relevant parties. International disagreement with a valid legal title is legally without effect. A boundary cannot be unilaterally declared, nor be internationally established, contrary to the wishes of the state on the other side of the line. The current boundaries between Israel and the occupied territories, which have a distinct legal status as such, are those laid down in the armistice agreements. Now, those armistice agreements, and I don't have the time to go through them, make it very clear that those lines were ceasefire lines where the armed forces of each side essentially stopped and would not in any way prejudice the rights, claims, etc. of the parties to the particular conflict, nor prejudice any particular peaceful settlement of the question. Accordingly, these limits are not legal titles as understood in international law as such. However, the armistice lines did become the limits of effectivities, marking the limits of the exercise of effective control by sovereign authorities, supported by international practice. The 67 boundaries, insofar as the West Bank and Gaza are concerned, thus have the same status as they did in 1967. That is, they are armistice lines, but also the limits of the relevant exercise of sovereign authority, supported by the relevant parties and by the international community, pending a final settlement of the Israel-Arab dispute. It is well known that various relatively recent attempts to negotiate a settlement were all based, to some extent, on the idea of land swaps, and I'm not going to go into that. It's an idea which has been supported by the EU, with the condition, of course, that it is agreed by the parties, the two parties concerned. One final point I would make, I have no idea where I stand with time, so before I get a response, which I may not accept, I will proceed. Sorry. The final point is with regard to statehood and responsibility. It is clear that an independent Palestine would be responsible for any breaches of international law attributable to it following independence. Since a new Palestinian state is likely to formally include Gaza, its that is the Palestinians' international responsibility, would encompass activities that are contrary to international law that may emanate from that area. Accordingly, the new Palestinian government would, as a matter of general principle, be liable for any hostile acts emanating from Gaza, whether by way of rocket fire, other armed activity, or terrorism, in the same way that it would if such activities emanated from the West Bank area of the Palestinian state. Secondly, on this final point, international law establishes that were an insurrectional movement subsequently becomes the new state or the new government of the state, international responsibility will be engaged. Just to draw this to a conclusion, because I can't go into the legal argument with the time left, thus the new Palestinian state would be responsible for any unlawful activities undertaken both by its previous incarnation, the current PA, and, in the event that Hamas is part of the government of Palestine, also any activities undertaken by Hamas prior to its joining the government of an independent Palestine. Now, on that point, I will have to end. I am very conscious I have merely simplistically touched upon the surface of some very, very complex legal questions. So at this point, I will pass over to you.
Thank you, Professor Shaw. That's very interesting. I'm particularly, I mean, some of the areas at the beginning, I think you would agree, are controversial in the sense that they are at least debatable. The point that I think you very clearly delineated is the distinction between membership in the international community and the question of frontiers. They are very, very distinct, and sadly, they are being increasingly mixed, at least in any media reporting at the moment. Now, Dr. Schartz, you've been many things today. You reminded us you're an engineer, you're a negotiator, now you've got to put a lawyer's hat on. Let's see how you do.
Not with really two major international authorities on the matter, so I will not, I will go more for your first statement about talking politics using international law. But anyway, I think international law is very, very important in defining relationships between countries. Otherwise, we have a jungle law where only power rules, where only capability in warfare rules. And therefore, you need the international law to put some constraints on people, on countries' behavior that is aggressive in nature and that attempts to take people's rights away. I mean, this is really my understanding of international law. And my understanding of international humanitarian law is you need protection for the civilians who suffer from the result of aggressive action taken by the stronger against the weaker. And until that is resolved, you need international support through international law and institutions that implement international law. Have I veered too much from the...
No, that's absolutely fine.
All right. So, I mean, I think even in this short capsule, very incisive, very interesting, we have resolved the issue to Mr. Gold, I mean, as to states and borders. I mean, declaration of the state will not settle the final border until final negotiations are made. I mean, this is something we never really had any doubt about. And there are peculiarities. We are really almost a sui generis case. For example, the agreement was not signed by the PA. The agreement was signed by the PLO, representing the Palestinians and Israel. And let's look at some of the interesting results of that. When we signed the Gaza-Jericho agreement in Cairo with the late Presidents Rabin and Arafat, came the issue of foreign relations. Well, how would the PA, which was created by the agreement, handle foreign relations if it expressly said that it cannot handle foreign relations? So what happened? The Gaza-Jericho agreement states that the foreign relations of the PA is handled by the PLO. which means that Israel recognized that the PLO is really the pseudo-state of the Palestinians until they have a final state, and that state handles all the foreign relations of the PA. Furthermore, every agreement we signed with America, with Europe, with anybody else, and with Israel is an agreement between the PLO to the benefit of the PA and Israel. So the PLO took the role of the state, and the PA was the creation of the PLO accepted by Israel. There are no agreements between the PA and Israel. All the agreements are between the PLO in the benefit of the PA and Israel. And therefore, when we signed this agreement, the state of Palestine had already been declared in 1988. And that has absolutely no problem with the Israelis that, in the agreement of Oslo and its consequences. Furthermore, we continued to get recognition of that state while we were conducting the peace negotiation with Israel and the PA. In 1994 itself, South Africa was liberated of apartheid, and it immediately insisted on creating an embassy for South Africa in the Palestinian territories, and threatened that if Israel does not accept that, they will close the South African embassy in Tel Aviv. But as a result, there was an amicable agreement, and South Africa was represented in Palestine and in Tel Aviv. Furthermore, all our relationship with East European countries, whose recognition was a result of their recognition during the Soviet times, between 1997 and 1993, I was foreign minister, we signed new agreements with every one of those states, and that in effect regained our full embassy status in every one of those countries. So the Czech Republic has a full Palestinian embassy, and Poland, and Hungary, and Bulgaria, and Romania, and Slovakia. And we created new full relations with the state of Palestine with those countries that were part and parcel of the Soviet Union, like the Ukraines, and Belarusia, and Kazakhstan, and Azerbaijan, and all of those. The only three countries of the old Soviet Union that we had not had full ambassadorial relations with the state of Palestine were Armenia, Georgia, and Moldavia. I've already visited Armenia. I'll be going to Moldavia very soon, and I think it's very possible that they will also recognize the state before we go to the United Nations. So we are not going to declare the state, Mr. Gold. We are not. We have done that some time ago. But we have been upgrading our institutions as we went on, and upgrading our relationship even with those countries that you call witnesses. Our status now in Spain and in France and in England have been raised gradually. That's why I'm saying it's a sui generis case. It's a very special case, because Palestine is a special case. It's the only colony left in the world today. And therefore, the question of recognition of the state as a member of the United Nations is what Ms. Abu Mazen will be calling for. He will not be asking the United Nations to accept his declaration of a state. He'll only be asking the United Nations to accept the Palestinian state as a member. And if you go to Resolution 181, also, I'd like to want to polish one's memory. We refused to divide our country, to partition our country in 1947. And we considered this is just like the story of the real mother in the King Solomon story, that we will not divide the child. We will give it to the other mother rather than divide it. This was our position then. But when Israel went to the United Nations asking for full membership, the United Nations required two requirements of Israel, and Israel accepted by the speech of Mr. Abba Eban. One, to implement fully Resolution 181, and the two, to implement fully Resolution 194, asking for the return of refugees. Go back to the annals of the United Nations. Israel had not applied any of these two. And in part of our request for a status of member of the United Nations, we will go back to 181. There was two states created in 181. One of them Israel was created, the other Palestine. Yes, it was created as a Jewish state, but if you want to go back to 181, let's go back to the whole 181, which award us 44% of Palestine and not only 22% of Palestine. You cannot dissect a United Nations resolution and take from it what you want and leave what you do not want. It doesn't work. Secondly, the issue of violations. I mean, thank you very much for talking about countermeasures and voiding an agreement if one party totally ignores and violates its conditions. I wonder, really, we talk about this as a violation of Oslo. My goodness, what is of Oslo that Israel has not violated up till now? All the area should have been under our total jurisdiction, pending permanent status negotiations. According to Oslo, we should have gone to permanent status negotiations with every bit of our territory under our full control, with the exception of Jerusalem and the settlements. Where is it now? In Oslo, we had full jurisdiction over the Palestinian people. Today, we have no jurisdiction over the Palestinian people. The Israelis consider Gazans in the West Bank as alien infiltrators that should be caught and sent back to Gaza. Today, the civil administration, according to Oslo, should have been cancelled, and the administration of the West Bank. Today, the civil administration had been regained and renamed, and it's full control of all the affairs of our people. I could not get a student of mine who married her friend in college and found out that he's going back to the West Bank and she is from Gaza. Up till this minute, they have been married 9 months. She cannot come and join her husband in the West Bank. Is this Oslo Agreement? The Oslo Agreement has been mutilated by the Israelis. They implement of it what they want. It's a selective implementation, which according to law is not implementation. When one of the parties selectively decides what to follow and what not to follow, he gives the other party the right to have countermeasures that will rectify the situation. So now, the issue of the Palestinians, their violation is that they are going to join the United Nations, whereas the violation of Israel had to do with the daily life of everybody on the ground. Is they becoming a member, if it will change the status of the PLO in the United Nations? How about changing the status of the people on the ground, which is really what will preempt the possibility of having a real state in the future? A mutilated state. You should come really and visit Palestine. Just take a taxi and go from Jericho to Ramallah. Go to Jerusalem. If you could recognize East Jerusalem, Arab Jerusalem, I'll give you a bet. You cannot recognize it. It's changing every day. The total area that the Israelis have taken is probably less than 2% of the land. But it's, again, very selective. It's very selective. It's in Jerusalem. It's over the water resources. It's in strategic areas. It simply puts control over every Palestinian. And therefore, again, I would like to come to a conclusion. Yes, we have the international law on our side. And yes, even after declaring the state, we will continue to negotiate with Israel borders, water, refugees, and every one of those elements. And yes, when we reach an agreement, we will end the conflict and end our claims. But that will happen is when we reach an agreement. We want our state to run our affairs and our international relations. And I think from our point of view, in our commitment to nonviolence, this is the best way to negotiate with the Israelis once the Israelis are ready to do it. Thank you.
Thank you so much.